Okay, people are starting to continue to trickle in, but I think you can kick us off, Sandy.
Okay. Hello, everyone. I'm Sandy Chapman and a senior paralegal at Husch Blackwell's condominium and HOA practice. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. We encourage questions during the program and ask.
You're muted, Sandy.
Okay, I'm sorry about that. We encourage questions during the program and ask that you use the chat to everyone or raise hand features to ask questions. A PDF of the presentation is available in the program materials folder. This program is pending approval from CAMICB and has been approved for legal education hours. We will send you an email tomorrow that will contain a certificate of attendance, sign in for CLE and CAMICB credit, a program survey, and a copy of the recording. That's all for the housekeeping items. Let's get started with our program. The speakers joining me today are Lydia Chartre and Dan Miskey. Lydia has extensive experience advising Wisconsin Condominium Association boards of directors on a myriad issues facing them, including declaration and bylaw amendments, assessment collection and foreclosure, rulemaking, voting, and governance issues, and HUD and fair housing issues. Dan helps boards of directors and managers of condominium associations, homeowner associations, cooperatives, and timeshares with many issues they face, including document amendments, collections, contracts, rules, and governance. Both Dan and Lydia are the only two Wisconsin attorneys admitted to the National College of Community Association Lawyers, which recognizes excellence in the practice. Thank you, and we will get started.
Good morning, everyone.
Morning.
Thank you for joining us. So we will start with our slide. So if we can go to the next slide, it'll be on sex offenders, the first part. Why can't you just prohibit them? We'll stay here for a second. The law has been, and we'll end up starting 10 years ago, but the law has been, you can. And you certainly could, depending on how your documents were written. And this is not obviously anyone's favorite subject. So it's a subject that I probably wouldn't be talking about today if there wasn't a brand new case that we all get to learn about from another district and what's going on. So if we now switch slides. So this slide is listing some of the names that you may or may not recognize from roughly 10 years ago. Some of them are actually quite a bit longer than 10 years ago. And you'll be seeing these individuals momentarily. But the concept 10 years ago was that, condominium associations were designed, and homeowner associations, frankly, were designed so that to be family orientated. And there was obviously a community pool in many of them. There were obviously community activities, and it was thought that restricting sex offenders, especially those that had to register as tier 3 sex offenders, so had some sort of violence in their past, made sense. And part of that made sense was as a result of the 5 people you see listed. So if we now move on to the next slide, we'll sort of cover who and what. And I'm going to let all of you read this on your own as we sort of page through the next 5 slides. They are hard to read. If we move to the next one. and we can move. And the next one. If you'll notice on this one, Roger Bentley is James Bentley's brother, so it wasn't enough that just one brother was involved. And this is the last one.
Mhm.
So if we move on. So 10 years ago, the advice was obviously to keep the individuals that were involved in being on the sex registry, especially those tier 3 people, from living in your neighborhoods. 10 years ago, our recommendations were as outlined here. Find out if there are any sex offenders in your neighborhood by checking the registry. Verify the information with your local sheriff or police. Decide if the board wants to inform the residents of the offender's presence. Notice I didn't say notify them of who the offender was or that person's address, because you still can't do that. Research your state's sex offender notification law and talk to your attorney. The recommendations continued. To the next slide, please. And that point residents to the appropriate resources. Don't ID offenders by name. Advise residents that it has a law against, obviously, intimidating and harassing registered sex offenders, so that registered sex offender list we're talking about is the one from, pardon me, one of the children we looked at. It came about as a result of Megan's Law. And then investigate the residency restrictions. So that was the part where we were recommending pretty universally to go, listen, look at what you're doing. Look at who lives in your community. Look at how your community is set up. Assuming you had families and children there, we'd recommend for tier 3 sex offenders that you restrict or prohibit them from living within your community. That was the recommendation that we were providing literally to every one of our communities, and in fact have amended many of your documents to allow you to, in fact, prohibit tier 3 sex offenders from living in your communities. So now the question is going to be, and next slide, please. So what's changed? And the answer to what's changed is this case that literally just came out on, it's a community, planned community with a restricted covenant that prohibited lifetime registered sex offenders from residing within the community. And I want to stress, in Pennsylvania. So at a 2013 annual meeting, they learned there was a sex offender residing in the association. And by 2016, they go, boy, we should probably pass an amendment that prohibits them from living here. Of course, they would have known in 2016 that the person that used to live there was then in prison for being a sex offender, but was still an owner of their condominium or of their, planned community. And therefore, prohibiting him meant when he got out on probation or got out of prison, he was going to be moving back into their residence. So next slide, please. So in 2018, he's released from prison and the association advises him that he needs to vacate the property. And he does what you would expect, which is refuses to leave. And the association files suit to effectively say, we're going to kick you out, and seeking a declaration from the court to remove him. It's essentially an eviction action. The owner who's residing at the association says, you can't kick me up, and we'll get into in a moment here why. So you get to the trial and the court decision, and the association did what I would have done had I tried this case, which was hired an expert witness to testify on the recidivism rate of sex offenders and the negative impact they potentially have on property values, and the increased risk of allowing a sex offender to live within a community that's as close together as most associations are, from the standpoint of you have a community pool, you have community other items going on. The manager of the association obviously testified it's a child-centered nature of the association and its pool. The unit owner, though, the sex offender on the registry, claimed that the declaration amendment was unconscionable and against public policy. His position was, I presented evidence that I've complied with all the requirements the state has set. I'm on the sex registry. I'm on parole. I haven't committed any offenses since my release from prison in 2018. Now, keep in mind, this case took a while. So, and the trial court found the prohibition against sex offenders was void as against public policy. And what the association, it also found what the association was attempting to do by protecting children in their community by banning this unit owner would have a negative effect and simply move the offender from their neighborhood with their children to some other neighborhood where they may be, in fact, even closer to families with children. The court went on, you can read it here, that essentially, all associations are child-centered. This isn't unique to this association, and sex offenders, deciding that you can decide they can't live there essentially puts a greater proportion of the sex offenders somewhere else, which, might protect your children, but is going to protect other people's children. So if we move to the next slide, please. So we're still under what's changed. Obviously, that decision by the trial court was appealed by the association. The association essentially argued we can't prohibit it. The law has long been in this nation that we can prohibit it. It's a freedom of contract. This is how we contracted. The court took the position that no, you're governing the documents, in fact, are a contract. But contracts, when they're against public policy, can be voided, just like contracts are voided or old declarations are voided that have racism as part of them. And the court went on to say that when the state, through the sentencing and parole authorities, places a particular offender in a particular program, it's already made the determination that it's consistent with the public's safety and the needs for the offender to reintegrate into the society. That means banning offenders with violent history from your community conflicts with the state's determination of what's safe and what's not safe. I'm going into all this because the reasoning ultimately is working its way around the entire country. So, do I expect this to be the law in Wisconsin? If you were asking me in 5 years, it probably will be. And therefore, the regulation of released sex offenders is controlled by the state and may not be controlled by local ordinances or restrictive covenants. That means your declaration, your bylaws, and your rules can't be more restrictive than whatever it is that the state determines. If you go to the next page, please. So the appeals court went on and said, okay, it unduly restricts and effectively reaches the conclusion that, the parole board gets to make this decision. You don't get to. Therefore, item 6, the declaration interferes with the statewide statutory schemes of public safety and rehabilitation, and the declaration therefore under 7 violates public policy, just like the trial court said, by unlawfully precluding registered tier 3 sex offenders from living, in this case, in this parole board approved home, because it was a planned community, not a condominium association. Can you argue there's a difference between a condominium and a planned community? Sure you can, because we have a statute 703 that governs condominiums. We don't have a statute that governs homeowners associations. Homeowner associations are more separated in space, presumably, and in time than condominium associations. But at the end of the day, I don't believe that argument is likely to be successful. It certainly, I don't think, would have been successful in Pennsylvania. I think the other argument that could be made would be an argument that you're placing children in an undue risk that they don't need to be in for the same reasons that they're not allowed to live within 2,000 feet, I believe it is, but it could be yards of a school. It's the same relative concept. So if we turn the page. So now what? You will notice we didn't change anything, really. It says so I'm going to cover both in Wisconsin and nationally. So in Wisconsin, same first 4 recommendations. Find out if there are any sex offenders in your neighborhood by checking the registry. If you see someone in your neighborhood who's under the registry and is a concern for safety because of the tier 3 qualification, you may then want to say, okay, let's call the police and find out what we can. Decide if the board wants to inform the residents of the offender's presence. And that would simply be that, we have a person who's registered on the sex offender list who resides in or near our community. And as such, we're putting everybody on notice. You can find the sex offender registry if you'd like at this address. The concept is just so that all of you are aware of it and what's going on. All right, so then next page, please. So you can appoint them to the appropriate resources, which was what I just said, which is to the official sex registry site. Advise residents that it's against the law to intimidate or harass. So if you're going to give them notice of them, you got to make sure you cover this second part, because otherwise you're putting yourself in jeopardy under some HUD rules that you don't need to be in jeopardy under. So don't take half of my advice here. If you're going to, if you check the sex registry, you see you have an offender living within your community, you have not passed a prohibition on that, and you intend to send out notices, you better send out the notice that says you can't intimidate or harass as well, or you may find yourself defending a lawsuit that you don't want to defend. So now 7 is, this is from a national perspective. My answer would be stay diligent and alert. From a state of Wisconsin perspective, my answer would be if you haven't prohibited them, you still can. It's up to you, but you can. If you have a need to, my advice would be you probably should. But that coming down the path, the anticipated future of this is that you are going to see that this prohibition, or the prohibition on restricting tier 3 sex offenders from living in your communities will be lifted by the various cases that are likely to work their way around the country. I think 8 self-evident. So that was it. We're going to end up taking questions at the end of the entire presentation. So if you have any questions, obviously on this or anything else, Lydia and I just attended the CCAL Law Conference along with our team. And 1, we had a really fun time, but 2, learned a whole lot about a whole bunch of stuff we want to share with you over the course of the next, 3 or 4 or 5 of these items. Lydia, it's all yours.
Thanks, Dan. Wow. Really, thank you for putting that presentation together and sharing it with everybody today. These are the real issues, guys. This is tough stuff. It was a tough message to deliver, but it affects every community that we live in, every community that we represent. And sometimes it's difficult to talk about these issues, but the reason why we do is because we feel it's our job as your lawyers to tell you about what's going on and help you prepare, because reality is what it is, and you guys are going to be in much better shape if you know what's coming down the pike, as opposed to being surprised by it, which is exactly what is spurring my portion of this presentation today. We're not talking about sex offenders anymore. We're talking about your condominium records and documents. I presented on this topic at the November CAI legal panel. So if you attended that, you already got the primer on this. Don't mind doing it again though, because I think it does bear repeating, so we get it in our heads exactly what these law changes are and what they mean to you in your community. And also, many of you on this call were not at the legal panel back in November, so it'll be news to you, and we'll get moving on it. So we are talking about changes in the Wisconsin Condominium Act that affect your association with respect to three areas: record keeping, financial records and audits, and website requirements. So Morgan, you can advance the slide. We'll dive in here. So in 2023, we have some changes to the Wisconsin Condominium Act, as I mentioned, and these are not just informational. These actually are things that you need to know because your association is going to have to take action because of them. Most of the changes that we are looking at are in one section, 703.20. And while it used to be that section existed in previous versions of the statute, but it was very vague and general. It basically said that associations should keep their books and records, and we could kind of fudge what we thought books and records meant, and it didn't give us much specificity at all. So now, very different, the new law is quite specific about the records that every Wisconsin condo association has to keep on hand, and also the unit owner's rights to access and inspect those documents. The second area we're going to be talking about only pertains to large condominium associations, which the statute now defines as 100 units or more. So if you are on this call and live in a condo association of 100 units or more, pay attention to this part. You are now required to maintain a website to house all of the records that the 703.20 statute now lines up for you to have to keep. And we'll get into the detail on that, so stay tuned. Finally, the statutes used to be silent on audit requests, and now this statute adds that owners can request an audit under certain circumstances from the association, and we'll talk about that too. So go ahead, Morgan. All right, so we'll talk about the documents that you have to keep, and these are defined as records now of the condominium association under 703.20. So this going back 6 years applies to each of these bullet points that are going to follow on this slide and the coming slides. So from now, count back 6 years. You need to keep on hand the minutes of owners' meetings and board meetings. That's not new. We've always said keep your minutes on hand, but normally in the past, we were looking at about 3 years rather than 6 because the corporate statutes talk in terms of 3 years. Now, if you're a condo association, we've got 6 years worth of minutes you have to have at the ready. Also, a record of any actions that the association takes without a meeting. So if your bylaws allow you to take action by a written or absentee ballot of the owners, as opposed to calling a meeting and voting on a topic, or if the board has an informal action in between meetings that you might okay via email, those records you have to keep together and include in your record book. Also detailed bookkeeping records that itemize all the receipts and expenditures that affect your common elements. So as we know, that's going to be quite a bit of paper or quite a bit of digital file there. Next slide. Annual budgets you have to keep for the last 6 years. And the statute gives us a few areas here that need to include under the category of annual budget. First, it's all the anticipated common expenses and the amounts you're going to allocate to your reserve account in a particular year. the amount and purpose of any other association expenditure. So if you think about what your budget looks like, these are just describing the line items that should be included in your budget, and probably already are. Number 3, the amount you have in your reserve account or are budgeted to have in your reserve account. Any common surpluses that may be there after your expenditures for the year. The amount and source of any income other than assessments. And finally, the amount of any assessments that are going to be levied against the owners. So the amount and also the purpose of the assessment, whether it's for regular operating income or to fund the reserves, etc. Next slide. So here we go, keeps going on, but I think this is the last one. So the other documents you need to keep on hand, going back 6 years, are your financial statements, balance sheets, etc. Bank statements and account statements, including your reserve accounts, income and expense statements, your insurance policies, an audit if you've had one done, all the contracts that the association has entered into in the last 6 years. And then they give you a little bit of a break, just going back 3 years. You have to keep all the bids, even for those contracts you didn't end up going with those contractors. If you had them bidded out, that needs to be part of your records. Finally, all of the invoices and expense related records for a given year, going back 6 years, that's what you need to have. Next slide. All right, so those are all the records that the statute requires that you keep. Now we'll talk about how the owners have rights to inspect these documents. Again, in the past, the Condominium Act was silent on this. We used to look to the corporate statute to give us a little bit of clue as to what to do with owner inspection requests. And because most of you are incorporated associations, some are not. So there was always a little bit of a gray area there. But here, very clear now in 70320, that any unit owner does have the right to inspect and copy any of those records that we were just talking about before, going back 6 years. And an owner just has to give 10 days written notice to the association, asking to inspect the records, and they can make copies if they want to. And then we get into dollars and cents. So while you can't charge the owner for time to come in and take a look at the records, you can charge them for a reasonable cost of the copies. You can also charge them for labor and materials to provide those copies, but no more than $150 if the actual cost is more than $150. So basically up to $150. And if you're wondering what labor and materials might be, the thing that comes to my mind, I think, is for new associations that have a professional property management company. If the management contract has a provision in there where they can charge the association for certain extra things by the hour, this might fall into that category where they have to work with the unit owner going forward, producing the documents, getting everything ready for them. And if they're charging their time to the association, to me, that would be the cost of labor that could be included in this $150 cap. So keep that in mind when owners are asking to inspect documents going forward. Next slide. So there are some exceptions built into the statute, thankfully, as to what owners are entitled to see or not. And they're kind of common sense. If you think about the kinds of things that a board might have to go into executive or closed session to discuss, those are the types of things that you can keep from owners because it's a matter of privacy. Sometimes it's a matter of attorney-client privilege. Say you've got litigation going on, and there's attorney documents to the board, correspondence back and forth, what have you, opinions. Those are the kinds of things that are attorney-client privileged, and you would not have to produce in an owner inspection request. Personnel records, records of other owners' violations you can keep. No, you can't go in and say, I want to see all my neighbors' violations and all the records related to that. No, those are protected. You don't have to give those. And no, they can't ask for their neighbors' delinquent account records. No, they can't see things like that. Those are protected by the statute. And finally, for new associations, newly built, newly developed, any financial records that are related to your initial construction of the project can be held back, can be redacted because you don't have a requirement to keep those to begin with. So those are spelled out as exceptions in the statute as well. So if an owner were to request, hey, I want to come in and see the records you have, yes, the association or somebody on their behalf, a manager, a board member, perhaps the attorney, should go through and redact the records to make sure that none of these categories of information remain on what they are able to see and not see. Next slide. Okay, so this is the real big fun one for associations that are large. So if you have 100 units or more, all of these documents that we were talking about, in dating back 6 years, we have to put them on a website. The legislature was nice and gave us quite a bit of time to get ready, but clock's ticking. This requirement kicks in April 1st of this year. If you are an association of 100 units or more, you do have to have a website and get all these records put together on there. It needs to be hosted either by the association, by the board, or it can be by your management company if you have one. And the law also requires that you have password protected access to the owners and managers of the association. So it's not public information necessarily, but it's only for the password protected unit owners and managers to take a look at. Next slide. Okay, final category, audits. Like I mentioned before, statutes used to say absolutely nothing about this. So we were not really worried about audit requirements unless your particular association documents had a requirement somewhere that audits were required on a certain yearly basis or every 3 years or what have you. So now the statutes do speak to it specifically. And what it says is that if the association gets a written request from at least a majority of the owners, so a majority of the owners have to get together and put a petition together for the board asking for an audit, then the association does have to go ahead and hire an audit done, and it would be at the association's expense. The statute gets a little more in detail for associations that are in the declarant control period, with a lesser requirement for the number of owners that need to get together to request this of the declarant controlled board. I think that was pretty smart of the drafters, because as we know, sometimes developers aren't as forthcoming with information as everybody would like in new developments. So this makes a pretty low bar, easy burden for owners to get at that documentation and have an audit done if they feel something's not right. Next slide. So as I mentioned at the beginning, the reason why we're going through all of this information with you and pounding it into your heads is because that's our job. And you need to be aware of these law changes and be able to get prepared for them so you're not caught off guard. And knowing this stuff will actually keep you guys out of trouble, because the last thing we want is a unwary association saying no to a records request that they didn't realize the statute says they have to have. And you certainly would be scrambling to get records together if you didn't know about it in the 6-year back requirement. So that is where we are. That is the conclusion of our presentation at you. And now we would love to answer some of your questions. I saw a bunch coming through in the chat while I was speaking, although I couldn't multitask and read them at the same time. So Dan, if you saw any questions in there, you want to kick us off talking about them?
Sure. Why don't I take 2 while you take an opportunity to look at some? I would guess there's about 11 of them in there. They're obviously divided based on mine came first and yours second, I think. But
makes sense. Yeah.
So the first question that I received was, what if the board decides not to inform, presumably the residents of a tier 3 sex offender, and a resident informs others? Does the board have a liability? So the gut instinct of everyone's going to be, no, how can I possibly be responsible for one resident informing other residents of something that they shouldn't inform them to? I would say that that's probably correct, but I think better advice is, if you learn of that, then you should certainly be taking on my step 6, advise residents that it is against the law to intimidate or harass a registered sex offender. And the reason why is because they would argue under the FHA rules that they are being discriminated against based on their, criminal history, I would say, being on the sex offender list, however you want to characterize that, and any other reason they can come up with. And unlike the past, we learned this past year at the National Law Conference, that HUD is taking much more seriously, and there were more cases this year, dealing with those unit owner to unit owner disputes where we used to say, leave that up to the unit owner to solve. We can't say that anymore. So that's my answer is, if you learn of it, make sure you advise everybody not to intimidate or harass. If you learn the intimidation or harassment's going on, you have a duty to step in and do something. So the second one was then, is there a difference for an association if the registered sex offender is a renter of a unit, not the owner? I'm going to go with the short answer. No. There's going to be no difference. The law will apply literally no difference to that. So I would not rely on that. And Lydia, I'm passing it over to you for the next one or two.
Sounds good. So I saw a question about audits. And the question is, for the audit requirement, is there any indication of what kind of audit is required? And if not, is the type of audit selected at the discretion of the requesters or the board? That's an excellent question, Steve. I can only tell you what the statute says so far. And basically, no, it doesn't get into detail about the kind of audit. Dan is my accountant, though. I mean, I know there's financial reviews. That's not an audit. An audit is an audit, but maybe there's different colors of audits.
Yeah, no, an audit has, in the CPA world, a particular inference. The problem is almost nobody wants an audit, but when they rewrite the statutes, they don't really care what anyone says because they think audit is the highest level of security. But what you really want to do is just, you want to check the cash. You want to make sure the cash went where the cash was supposed to go, and the rest of the stuff that's normally involved in an audit may not necessarily be the best spent money you ever did. Having said that, I mean, an audit should be testing your vendors. It should be testing, your membership payments. It should be matching them up to your dollar amounts. But normally an audit's relatively significantly more expensive than some sort of a review that you might be just as effective for what you really care about, which is that the cash you're supposed to have, you actually have.
Right. So I guess the answer is an audit's an audit. So if a unit owners get together as a group and say, hey, association, we want one, then you would contact a CPA and request an audit and go through the scope of it. The statute doesn't get into who decides the detail on it. So I guess what I'd advise is, if this happens, to have the board sit down with the requesting unit owners and just kind of talk through the cost involved and the different options. Maybe once you talk to a CPA as to just to kind of get to the point of what do you really want to see, what's important to you and your group, so make sure that when you hire the work done, it hits all of those bells and whistles. So it's not just one party. It's not us versus them. It's not the board saying we get to decide the scope of the audit. It's why don't we work together and figure out what you want to see and make sure it's in the work order. Does that make sense?
Yeah, I like that approach. I'm not sure who asked, but I like that approach. I like the approach if by chance one of them is an accountant, that would be great. If one, not to have them do the audit, but for them to help with the scope. And if one of them's not an audit, not a accountant or CPA, to have them talk to whoever their CPA is and say, let's have our CPAs talk and agree on what makes the most sense for what is really going on here, so we limit the scope to the extent possible.
Great. Good. The very next question in the line here was from John Cross, and I believe this is on sex offenders. He asks, should a prohibition be placed in the declaration, bylaws, or rules and regs?
So here's my real answer. Where should it be placed? Probably in the declaration or the bylaws. I don't really care which one. I prefer it in the declaration only because when it gets recorded, you can see it. That would have been my answer probably up till now. I mean, and even now, having it in the declaration is nice because it's recorded. Everybody knows about it. At the same time, if you end up having to amend it because the case comes down that says you can't have that, it sure would be easier to amend and less expensive word in the rules and regulations. So based on what's going on now in the world, I'd probably put it in the rules and regulations and then record an affidavit of these are our updated rules and regulations as of whatever date. That way everybody has notice of it, but it's easy enough to change.
Great. One question about the new statute. Is the 6-year record retention going back 6 years from 2023? Today, yes. So I guess we always look back 6 years from the current time. So starting now, we would look back 6 years. And for today, if someone said, I want to inspect the records, it'd be 23, 22, 21, and so on, back 6 years. That's just going to continue to be to follow as the law goes forward.
Which seems
Go
yeah.
ahead.
I was gonna say, which seems to actually answer the next question. If you just became a large association, are the requirements forward-looking only? Well, no. I mean, you still got to keep the records going back 6 years. The requirement doesn't take effect till April 1st of 2023. So they'll be forward-looking as to being on the website, but as to keeping the documents, you already have that requirement.
That's right. Yep. And if for some reason you became a large association because of a merger or something, if you merged 2 condos together and now you're 100 units as a merged, then I would say at that point you would have to get your website together. So I think that's the only thing I could think of in how you would become a large association later. So hopefully that helps. I think we skipped over one about sex offenders.
I didn't see it.
Do you see it from East Ridge Homeowners Association? Can the governing document state that the board can have the ability to deny a sale of a condo unit to a sex offender or convicted felon for a crime involving armed robbery or other violent crime? So maybe they're asking, is it the same analysis for other felonies?
As of right now, I don't know of anything that prohibits that. You know, it's a freedom of contract. It's the unit owners agreeing what they want in their contract. I wish I had pulled up. I don't believe that is one of the protected classes, as you've been accused of a. Is this accused of a crime or convicted of a crime? I'm gathering convicted because.
They said convicted.
Yeah. I don't think there's a protection there. So I would say you can do it right now. I just would need to look at the HUD's latest list for whether or not a protected class includes ex-felons. I don't think it does.
Mm-hmm. Questions keep on coming. Do you want to?
Sure. How much detail needs to be listed for the account at the attorney? Do all invoices and references of a unit being at the attorney need to be removed or redacted? I don't think you've got to remove the part that says it's gone to the attorney, but that does tell you there's a collection now that I just thought about that, which means there's a debt, which you can't disclose. So I completely changed my mind in the course of 5 seconds here. Yeah, you do need to redact that from all references because the implication is there's a debt. You can't share the debt information because it would violate the Fair Debt Collection Practices Act, which you're not subject to, but it could be viewed as harassment. I would take it off.
I think so, like in the context of board minutes, when they say we're sending unit 10, 5, and 15 to collections, they could just redact the unit numbers, right? It could still say sending unit blah, blah to collections, but they wouldn't know which ones.
Yeah, you could say we sent, I would redact it and just put in parentheses, we sent 3 units to collection.
Right, exactly. And on attorney invoices, there's things that, because we list what we spent our time on, right? And an itemized basis on our invoices. And oftentimes we may have attorney-client privilege information in that time description because we're talking about what we gave advice on or what we had discussed with the board. So attorney invoices in particular would need to be pretty heavily redacted before being given to an owner for inspection purposes.
Do you have to give? I would claim the entire invoice is,
Attorney-client privilege.
yeah, except for the bottom line amount. And go,
Right.
listen, I'm not, I'll redact everything and let a court decide you've got to give something other than that because you don't want to waive attorney-client privilege.
Sure, that makes sense to me. All right, what else do we have? And what I should say too, I know we're going through the questions in the chat, but if anybody wants to talk, that's kind of the fun part of having it this Zoom format as opposed to what we've done before where we can't see you. We can see you. So if you want to turn your camera on and unmute, and I think you jump right up so everybody can see you. If you want to have a question, that's fine too. I want to make this more interactive if we can. If anybody's brave, go for it.
So you listed one of the ones while we're waiting to see if anyone wants to jump in. Does a HOA need to carry workers' compensation insurance coverage if the HOA has no employees? So the answer is legally, no, you're not required to have it. Realistically, absolutely 100,000% you should have it. And the reason is because in case someone gets hurt on your property doing work, however you want to define work, you're taking the risk that they will be found to be an employee because you would have controlled the means and methods or something else, or you hired someone who didn't have workers' comp insurance, which is how most of the people get hit, is because they hired a contractor who thought he had workers' comp insurance, had let it lapse. They don't have it. If you have it, you're protected. And it costs you about $200 a year, if I remember right.
Right. So I think Nikki popped up first. Go ahead, Nikki.
So some of our larger condominium associations have employees, and typically the financial statements we produce have copies of their pay stubs, which would list their home address, as well as any garnishments or child support that is being collected. I would assume that's private information that needs to be redacted as well.
I would agree with you. I think that falls under personnel records if we were looking for a category under those exceptions.
And then you also said removing the invoice, but on certain like GLs and cash disbursements, it simply shows an amount and the unit name or number, and then your name or whatever attorney name there is. I'm assuming that needs to be redacted just to not show the unit, but can we leave the amounts listed?
Are you talking about amounts collected in collections for assessments or?
So when we have our bills, it'll show that we cut a check to this attorney, and in the description, it'll say, unit 112, Husch Blackwell. Does that need to be redacted because it says that information?
That's a really good point. I think so, yeah.
Also, that amount is there. And based on what Dan previously said, the amount is okay, just not all of the content. Is that accurate?
That's right, Dan, correct?
I was trying to read through the questions. Could you repeat that, Nikki? I'm sorry.
No,
but so basically we have descriptions sometimes in cash disbursements or internal accounting reports that say unit 112, Husch Blackwell, and then the amount that was paid. I'm assuming that needs to be redacted because it shows the unit, but can we leave that total there? Because that's not, attorney-client privilege, because it is a bill that the association is paying.
If it's payment of our fees, you can leave it there. If it's payment by the unit owner, you got to take it off. So I'm just trying to make sure I understand which way, but yeah, because they're not entitled to know the debt of a unit owner. So anything that would let them calculate the amount of the debt or payment on a debt, you should redact.
Thank you.
Sure, absolutely.
You're welcome.
So
Susan.
go ahead.
Go ahead, Susan.
Okay, question I have is, in the past, we have listed by unit numbers, not by name. So do we have to remove all those all those unit numbers from past minutes? Or is this just going forward from April 1st because we cannot list unit numbers?
I was having trouble hearing. Did you hear that,
Yeah,
Dan?
I was going to say the same thing to you.
Shoot.
Linda, can you repeat that a little closer?
Yeah, I just turned up the volume. In the past, in our minutes, our board minutes, we have listed unit numbers of units that are in arrears, not names, but unit numbers. Is this something we have to go back into our past minutes and redact? Or does this law now apply only going forward?
Okay,
Question.
I'll take this one. It's a collection one. You can't put the unit numbers in your minutes. You can't discuss the unit numbers at your board meeting unless you're going to be in a closed session. I mean, you can have them on a piece of paper that only board of directors get and go, okay, we're going to talk about delinquent unit 1, delinquent unit 2, without it obviously referencing actually unit 1. But you can't have, yeah, unit 305 is way behind. You can't have that discussion, not in public. So you have two choices. One, just simply say, we're going to talk about the first unit on our list. And here's what we're going to do. We're going to send it to our attorney without ever referencing unit owner or unit number. Or you can go into an executive session and talk about them and then decide what you're going to do.
I understand that, but in the minutes, in the board minutes. So
Yeah,
this board
I'd go
members
back and take them out. I'd go back and take them out.
take them out. Okay, thank you.
I just put 5 units, 3 units, whatever it actually is.
Okay,
Okay,
thank you.
absolutely. So I see a quick question from a Diane Miller, and we'll then switch back. My association is less than 100 units. Does that mean we don't need to pay for an independent audit? Can we just audit internally? Lydia, you can correct me if I'm wrong, but the audit provision is unrelated to the 100 unit provision. The audit provision applies separately.
Correct, to everybody. And only if you have a majority of the owners requesting it under the statute. So that's the only time it's going to come up.
So I would just continue to review the documents however you do, making sure you have the cash you're supposed to have and you're only paying the bills you're supposed to be paying.
Right. We had one more hand raise, Eastridge.
Hi, my name's
Hello.
Jennifer, by the way.
Hey, Jennifer.
A quick question regarding records. I currently have an owner. We do have security cameras around our condominium building and within our parking garage, and they are requesting to view those without really any explanation, but stating that those are technically records of the condo association and that they should be able to review those as well as with minutes and so forth. Our current governing documents that cover our security cameras, we do allow people to view them if they have a reasonable request saying somebody, there's a dent on my car. I think maybe somebody hit my car. And then we kind of get a timestamp and we'll go ahead and review that video with them. But how do we address that? Because I don't believe personally, but my personal opinion doesn't matter, whether or not the government or the recordings of our security cameras are actually records of the association. So
Right.
how would you properly handle that or respond to that owner? Do I have to show that person all of the security cameras just because they want to see them?
Nope, I don't think you do. And I think the rule that you've passed sounds reasonable. So I think you should just stick with it. Thankfully, the new statute did not include among the itemized things, security camera footage. So I
Okay.
think you can safely say that the new statute doesn't include those records.
Okay,
So
thank you. I
stick to your
appreciate it.
rule.
Okay,
You bet.
thank you.
Mhm.
So the next question I saw was 100 plus unit owner associations. Does that only mean condos or would that apply to HOAs as well? It only applies to condos until they next amend 710.18 and add it to HOAs, but as of right now, it only applies to condos. Also,
That's right.
the new statute requiring homeowners association to register with an annual report with the DFI with a deadline to file of January 13th, 2023 to be compliant and be part of the searchable website. Does this definitely exclude condo associations and only apply to homeowners associations?
Yes.
I knew you were going to say that, but I like it better when you
You're
say
not, oh, actually, because I looked at that again recently. So yeah, that's that new statute that you're talking about with HOAs registering with the DFI. That's just subdivisions, not condos. So that you're safe on. And I meant to mention that earlier in my presentation too, that all the things that I talked about today with the changes to 70320, records, website requirements, audit requirements, those are just in the Condominium Act. So they only apply to condominiums. If you're not a condominium, you can just go, we don't have those. But like this question raises, there is new changes to the statutes that apply to HOAs in the last year too. So if you don't know about those, I think we have a blog on it, Dan, on our blog page. But if we don't, we need to write one.
The next one question I saw is from John Cross. The statute has exceptions for small associations. Is there an exemption here? No. The answer is no. You don't get out by being a small association. That shows up one of two ways. It's under 703. Let's take a quick look. 365 for the small condominium would be exception in there, or there'd be an exception actually in the statutory section 703.20. There's no exception under either of those. So there's no exception.
That's right. That's right. I see Judy with their hand up and we have just a couple more minutes. So I want to make sure we get to Judy's question if you want to unmute.
Thanks, Lydia. My
Sure.
question is the hard and fast date of April 1st mean that you have to have all of those documents in complete format loaded up on the website?
Uh-huh.
Especially in our case, which is dissimilar to probably many others in that we are a seasonal situation.
That's right. Yeah. They didn't give us any carve outs for anybody. So I guess we're kind of stuck with it. Maybe you can hopefully bank on the fact that nobody's going to know about it. So I would just go as quick as you can as a board to get that together and hope that nobody makes these requests or starts telling you you're supposed to have that website up already.
Yeah. Okay.
Yep.
Thanks.
All right. I'm going to read one more because I think this one's interesting. It says, what is the requirement when the association changes property management companies within the past 6 years? Is the new management company responsible for the previous 6 years, even though they've only been involved with the association for 1 year? When you say past 6 years, are you looking at 2016 to 2022 records? The answer to that question is yes, that's the time frame. And yes, the association is responsible for those records. You've got a management contract. You're responsible for what your management contract requires you to be responsible for. I'm going to guess to maintain the records of the association, but I'm going to also guess that the prior management company's contract required it to maintain the records of the association. And if they didn't and provide them to the new management company, they would theoretically be subject to suit for a period of 6 years because that's the statute of limitations on breach of contract as well. I know that's a much longer and more complicated answer than you probably wanted, but the short answer is you need the previous 6 years of records and you got to find out how you're going to get them as an association. Whether or not the property manager takes on that requirement is up to the property manager, but I get it.
I saw one question that's a quick one, easy to answer, so I'll do it in our last minute here. Darlene Fink asks if you've got 100 unit plus association, is it okay if the property manager has a portal with the 6-year document requirements that's accessible to the owners? Yes, the property manager would count as that third party under the statute that can host the website for the association, and that's perfectly fine. So as long as you've got a website up with the password protected, only owners can access the documents, then you're good to go. And I think Sandy has a closing message for us.
Thank you, Lydia. Thank you, everyone, for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program is pending approval for CAM ICB credit and approved for legal education hours. We will send you an email tomorrow, which will contain a certificate of attendance, sign in for CLE and CAM ICB credit, a program survey, and a copy of the recording. This concludes our webinar, and thank you for joining us. Have a great day.
Oh, wait,
Thank you.
wait. But we're going to respond to the questions we didn't get to in the same fashion we have in the past, which was we'll email the responses to everyone. We'll divide them between Lydia and I for any of those. And that way everyone will have all the answers to all the questions. All right. That was it. Thank you.
Thanks,
you.
everybody. Good to see you.
Thank you.